Okay, so good evening, everyone, again to this virtual discourse session brought to you by UOW Malaysia KDU School of Business here, specifically looking into the SME survival kit. Know your legal matters. Yeah, know your legal matters. It's extremely important now in the new norm. The businesses needs to change or reformulate the business ideas and concepts and structures, perhaps, and we have to look into any concern in terms of the legal matters itself. Yeah. So today we have very two distinguished guests, which my colleague later will introduce to you as well. Yeah. So a little bit of about who we are. KDU, UOW Malaysia KDU. Uh, UOW stands for University of Wollongong, Australia. So KDU itself has a span of 36 years of history. We have the first college back in on the Damansara Jaya side, and then we have the also another campus in Klang Valley, which is in Glenmarie. The picture that you see here, this is our signature campus of University College. We have also another two more campuses up north in Penang. One is in Batu Kawan, the new one, as well as the existing one is in Georgetown, yeah, in the Penang Island. So being part of UOW Global Network now, basically the access for academicians as well as the students into different expertise within UOW global network is much easier in different nations. And that includes in Australia, Hong Kong, Dubai, and of course now in Malaysia itself. Okay, so a little bit brief of the session for this evening here. We'll be talking about the impact of global economic slowdown and COVID-19 on specifically on SMEs. That's the purpose of this session is to provide some survival tips for the SMEs in terms of legal matters. Yeah, and as I said earlier on, this is a time where a lot of businesses will be preparing themselves for the new normal situation. So it's good for us to look into some of the commercial and employment law to further enhance their business sustainability in that sense. Yeah. So panelist session for today, I will pass on to Yvonne. Is my colleague. She is the head of law school from the college side. Yeah, Yvonne, please.
Hello, everyone. Welcome on board. And today we have our two very distinguished guests as well as panelists. So the first one is, of course, you may see from there, Dato Teh. So Dato Teh is a senior partner from Messrs. Teh Kim Teh, Salina Co. So specializing in, of course, for today's session is commercial law. So he's also the vice president for the China Asian Legal Cooperation Center, as well as the vice president for Persatuan Usahawan Maju Malaysia. So furthermore, he is not only just a lawyer, he's also the invited guest or visiting professors, associate professors for the School of International Law, Southwest University of Political Science and Law in China, as well as the School of Law in Hainan University, China as well. So thank you, Dr. Teh, for coming on board.
And thank you.
And the next panelist that we have here is Mr. Arun Kumar. So he is very, very, of course, famous for those of you that who are on board and have been following his session throughout this MCO. He's a senior partner of Messrs. Arun Kumar and Associates, specializing in employment law. He's also the legal advisors for the Asian Football Confederations, as well as the appeal boards for club licensing in Football Associations Malaysia. So being a member as well for the Legal Aid Management Panel on Employment Matters for the Council. And it doesn't stop there. He is also the trainer for the Malaysian Institute of Human Resource Management. So with here today, Mr. Arun will be sharing more into the employment law. So thank you, Mr. Arun, for being with us today.
Thank you, Yvonne.
So I shall then pass this back to my host, which is Dr. Brian, to run through the whole session.
Okay, thank you very much, Yvonne. So there you go. We have these two distinguished panelists for you to talk to, yeah, in terms of commercial and the employment law as well. A little bit brief of the issue that we are looking at today, yeah. As of yesterday evening, based on Bloomberg, now the COVID cases around the world has already passed the 4 million marks, yeah, and it's reaching almost 280,000 deaths worldwide. Okay. Of course, we know that in Malaysia case, it's slightly substituting down, and it's a good thing, I believe, for us in Malaysia case. And nonetheless, the Prime Minister has also announced the further extension of the CMCO up to 9 June of 2020. I guess, again, it's a precautionary action from the government to ensure that we are able to curb the further expansion or of this COVID-19 virus itself. Yeah. So at this point of time, it goes into phase 5 of CMCO extension up to 9th of June 2020. Yeah, and nonetheless, several businesses already can resume from 4th May onwards, as long as they follow certain SOPs suggested by the government itself. So how does this really impact on the SMEs business reformulation itself? Something that we need to look into. Just for everybody's in the same page here, the definition that we adopt for SME, the small and medium enterprises, in this particular session is by the SME Association of Malaysia, which separate into 2 different categories. One is on the manufacturing side, and another one is on the services and other sectors. Yeah, so this is where you belongs to. Any numbers goes less than the small enterprise, it is considered as a micro enterprise then in that case. Okay. So a little bit of the Malaysian economic stimulus package has been introduced, announced earlier on. In fact, the first stimulus package was announced back on the 27th of February 2020 by the then interim Prime Minister Tun Dr. Mahathir Mohamad, that worth about 20 billion ringgit. And a month later, the existing current Prime Minister Tan Sri Muhyiddin Yassin announced the first Malaysia Prihatin economic stimulus package that worth about 250 billion ringgit. And 10 days later, he announced another 10 billion ringgit as the additional Prihatin economic stimulus package for SMEs specifically. Okay, so these are a little bit of the progress of the timeline. And besides that, also you can see recently the government has also reduced the rate, from the bank negara side to spur these private consumption as well within the country. Yeah. Some of the impacts has been announced through the newspaper. For example, the Star has reported about SMEs are running out of cash now. So a lot of SMEs are facing cash flow problems, and therefore it's really a time for them to reformulate their business. And some of them have taken a bit more drastic action, for example, closing down of businesses, as well as retrenchment of staff as well. Also happens here too. Yeah, and to a certain extent, salary cut is also being practiced by a lot of small and business enterprises, when especially 2/3 of the businesses are seeing zero income. Yeah, during this COVID-19 and MCO situation. Yeah, so all these are relatively negative information. Unemployment rate has been high since the March this year. Yeah, we hope that it will not go too badly in the next 6 months. Just keep our fingers crossed. Okay, and some of the legal matters for SMEs also has been resurfaced. MTUC talks about stimulus package for SMEs fails to protect workers' job security. Yeah, we talk about retrenchment, for example. Yeah, and how does legal consequences will be there. Something that we want to ponder in today's session. Yeah. Also, we talk about the COVID-19 law to help the economy to recovery. Yeah, so this is also very good to get the opinion and the views from our panelists here today. What exactly is this COVID-19 law, and how is it going to affect SME businesses as well as consumers like all of us here? Okay, so something for us to look into. Yeah, so that is a bit of a set of the background of today's session, and I would not to further dwell further into it. Let the panelists to share with you the expertise on this particular matter. So for the first panelist, I would like to invite is Dato Dr. Teh for your view, please, Dato.
Hi, very good afternoon, ladies and gentlemen. First of all, thank you to the University of Wollongong and KDU to invite me to share on this platform. Dr. Brian, I have 5 minutes. Is that right?
Yes, correct. That's right.
Okay, I try to make it concise. I think thank you again, Dr. Brian. Thanks, Yvonne, for contacting me to speak and share the knowledge in this platform. And I'm also very honored to share this stage with Mr. Arun Kumar, who is quite an established lawyer in terms of employment law. Now, look at the COVID-19 situation. I think before these slides that you're seeing now, the slides before, there's an article on the Star where there's a big sun dated the 11th of April. That is actually my article to the Star to say,
okay.
to actually, if you scroll down Yes, 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 the one, yes. Next, the one that you have to construct. Yes, on
Right,
the right. Malaysia needs the enact COVID-19 law to help the economy to recover. That is actually a piece of article that I written to the Star,
right.
that I share in April. So we see that COVID-19 has huge impact in all the countries, all the region. No country in the world is spared from this. As we were having this discussion right before we started, Dr. Brian said that this is something unprecedented, and I will say that this is a game changer. A game changer. That means all the businesses, whether you are big or small, you are affected. So you can look at it in a very a negative way, saying that the impact is huge. But if you were to look at it in a positive way, it is also another way to reset the entire business environment. Meaning, whether you're big or small, everybody back to the baseline, and you start to run again. So today I will share this thing in three these sections. The first section I will talk about the commercial aspect of it, and the second section I will talk about some employment issues, and third section about funding, that what the company can do. Let's start about the first commercial this section. I think as company, first of all, I think first or second week of this MCO, most of the company are shocked. They were shocked. They don't know what to do. Then you see third week and fourth week, everybody start to call their lawyers, and a term which a lot of people have not heard about before the MCO. Then it became a very famous term. It's called force majeure. Force majeure. So this is a legal concept where when there's unexpected things happen, then you can get out of the contract. So a lot of people have been calling me about, this contract I entered into, the contractual relationship, but I cannot perform the contract. So I think for the businesses, look, you're watching this, or the students, you may look at study this force majeure, whether are they applicable to the contracts you have actually entered into. Now, contract can come, within the contract with your suppliers, your vendors, your customers. So I give you one example. A housing developer, they have actually contracted to build the house and deliver the house to the purchaser within 3 years. But during this MCO, they could not get the raw material. And of course, the people could not work on site. So the time is delayed, for example, 2 months. Now, the 2 months, who's going to be responsible for that? All right, that's one example. Another example is I actually contracted to sell certain things and deliver to you on the first week of April. But everybody knew that, first week of April, we could not work. So I failed to deliver the good to you. So does it mean that, I'm liable to a certain liquidated damages in the contract? So you have to look at it, the force majeure in the contract, whether it is a term that is included inside. So if it's not included inside, then you have to discuss and negotiate with the other party how to resolve the issue. But I'm looking at the moving forward, post MCO. I think this doctrine of this force majeure is something that everybody has to review again their contract. If it's not inside, and you have to ensure that you look for a lawyer to review their contracts and whether they can actually insert this in the future. The second, I make it very quick. The second sector that I want to discuss is employment. About a lot of people ask, my companies need to pay me full salary, or can they cut my salary and all this. So the Ministry of Housing, the Ministry of Human Resources has come up with several FAQ and guidelines that is very pro to the employees. Basically, in short, you cannot cut the salary, you cannot cut their leave unless they agree with it. So this one I'll let Arun to actually elaborate more, especially when the companies actually forcefully cut their salary, or they retrench people. So there are certain steps you have to take before you actually go for retrenchment. Right, so that's the second one. Third one, I'll talk about funding. I think moving forward, funding of companies. So you have to look at the subsidies that maybe there are certain subsidies that apply to the government, or the wage subsidy. Malaysia is 1,002. Some companies 800, and some 600. I have spoken to several lawyers around the world. They are for example, Singapore government actually they gives up to 75% from the wage, so to
Okay.
subsidize, and in the UK it's 80%. So Malaysia is 1,002, right? So it depends on the country, but whatever we have, we can apply to the government for the subsidy. On the other hand, there are certain grants that the company can apply. Some are interest free, and also it is time if you are financially strapped, cash flow issue, you can do some corporate restructuring, whether you are inject fresh fund from the shareholders, or you speak to even your supplier, even your in the chain of supply. Some people are saying that they have problem now. Instead of waiting, then maybe I'll invest into another company which is related to me. So I think restructuring is another way of getting ourselves out of this. So what I'm trying to say is businesses cannot just look at it from the business point of view. While you're going through this, it is very important to engage a lawyer along the way. Even, for example, employment issue, employer-employee agrees on a certain package, they agree on certain things, then it has to be in written form. So law as well as business must come side by side. So during this post-MCO situation. Right. So this will be a brief introduction that I can cram everything in 5 minutes. But feel free to ask any question if you have. I'll be happy to answer that. I try to stick to the 5 minutes time. Thank you, Doctor.
Okay, thank you. Thanks a lot, Dato. Yeah. So I think there are three areas that Dato has highlighted earlier on. The first one is the contract situations, right? The second one is on employment, and the third one is on the funding issue. Yeah, especially when your company needs to restructure. What are the legal matters that you may want to get opinion from the lawyers instead of just thinking from the business perspective itself? Yeah. So again, let me just remind the participants here, the attendees here. Thank you very much again for attending this evening session. If you have any question, please leave your questions in the Q&A box. Yeah, Q&A box instead of the chat box. Then we will get the panelists to address to your questions soon later during the Q&A time. Okay. Next, I would like to invite Mr. Arun Kumar for your view, please.
Thank you, Dr. Brian. Good afternoon, everyone. Now, let me straight away go to the main issue here. I think the two key words which you are facing now for SMEs and employees are sustainability and livelihood. One is SMEs and employees, they want to sustain themselves, as well as there's an issue of livelihood for both SME owners and the employees. To this effect, the government is trying to play a role to ensure that SMEs stay afloat, and also employees are not retrenched. This is because if employees are retrenched, it reduces the spending power, because employees eventually are the consumers themselves. So if the spending power is reduced, the economy suffers as well. So to that effect, my distinguished friend has said that the Ministry of Human Resource came out with an FAQ. There was a lot of confusion whether this FAQ amounts to a directive from the government that so-called says the employer cannot give unpaid leave, cannot reduce the salary. Now, the FAQ is an FAQ. It merely is a guideline. It was never a directive. It was misconstrued as a directive. Now, having said that, does it mean guideline has got no force of law? If the guideline states the established law, then it still has a force of law. Because if the guideline is merely stating the applicable laws, employment laws in the country, then both SMEs and employees have to still conform to it. Now, the first issue is whether whether SME owners can reduce pay of the employees. At this moment of time, cash flow is an important situation. They want to reduce salary before going to other steps like retrenchment. Now, can that be done? Now, as the law stands, it says that you need the consensus of the employee. It cannot be a unilateral decision. So you need to negotiate with the employee. Now, how is this going to be done? Now, if you just tell an employee that I'm going to cut your salary 50%, obviously, if he had benched his commitments to a salary of say 5,000, if you cut 50%, 2,500, it's going to be a pinch to him. And bearing in mind the moratoriums for hire purchase loans and so on is only for 6 months period. Now, the solution to this is, my advice would be, you can offer a pay cut to the employee, but the pay cut cannot be perpetual. That means after 6 months or towards the end of the year, it has to be reviewed based on the sustainability of the company. And if once the company is moving forward, they have to be brought back to their earlier salary. If that is the way you approach things, it will be easy to achieve a win-win situation, because ultimately both SMEs and employees are in this together, right? We can't be seeing each other as enemies in this, but we are together in this ship, and together in this ship we need to cross the wave. So so that's one issue of pay cut. Secondly, unpaid leave. Can you offer unpaid leave to the employees? Now, again, it has to be with the consent of the employees, but the government has introduced the employment retention program, whereby if the employees agree to a minimum of 30 days of unpaid leave, the government pays 600 to the employer to be given to the employee. And this is for a period of maximum of 6 months. On top of that, in order to sustain sustainability of the SMEs, the government has introduced, as my learned friend has said, the wage subsidy program. So if you are an if you are an SME with 75 employees and less, you get 1,200 wage subsidy. If more than 75, less than 200, 800, and more than 200 employees, you get 600, capped to a maximum of 200 employees. Now, is this enough? Is this enough? It all depends how soon we start, how soon our economy recovers. Now, if despite this subsidy, employees, SMEs need to retrench, then retrenchment has to be done properly. Right? Retrenchment has to be a last resort, because ultimately retrenchment causes severe, not only economic implications, political implications as well. So how do we staff off retrenchment? Is that negotiate a pay cut if possible. Retrenchment as a last resort. Negotiate a pay cut. If you still can't, then you go to retrenchment. Of course, you have to comply with the retrenchment principles, like last in, first out. That means employees which came in last have to be retrenched first, right? And then you have to retrench the foreign employees first, okay? And so on. And then you have to notify the labor department. So basically, these are the crux of the main issues in terms of employment issues facing SMEs and employees. Of course, other issues facing SMEs is that the government is allowed for EPF contributions on the part of employer to be restructured or deferred. So this will enable cash flow for the employers. HRDF, Human Resource Development Funds, are deferred for the next 6 months. So this again will enable cash flow for the employers. Ultimately, all these benefits is focused in one area: to sustain employees and SMEs. Employees need work, and to sustain their work, their livelihood as well. I think that's all for in terms of the short presentation. I'll pass back to Dr. Brian.
All right. Thank you, Mr. Arun, for your sharing. Now, let me just do a quick summary for those participants who might have missed out. So, Mr. Arun has further mentioned or summarized that we can, for every company itself, at the end of the day, retrenchment is, of course, the last resort, because looking at the subsidy that the government has given, and then all of the supports that the government has been lending to the employers as well, because at the end of the day, to retrench an employees, it is not the right options, because it will, of course, affect the companies, not only the companies, but economy and political as a whole. So thank you, Mr. Arun, for your session and your sharing. Now, we have one question over here. I believe that it could be answered by Dato Teh here. By Yitman Lo. Can you brief how to do a corporate structuring?
Come
So,
again? You
we
saying?
have a questions. We
yeah.
have a questions here by the
Alright.
participants.
Yeah.
Participants are asking for both of you to actually brief on how to do a corporate restructuring. So maybe we can start with Dato on corporate commercial, and then later maybe employment for Mr. Arun.
Yeah, I think corporate restructuring is a wide word. There are many ways of doing it. Restructure in terms of, for example, your shareholding in the company. So restructuring may mean that maybe I need fresh funds coming in from the new shareholders. So during this period of time, we restructure the the shareholding. Then it could also mean that you go out and take certain loan from the financial institution of the bank. So that is another way to sustain the business. So when we say restructuring, it comes in different way. Another way is a restructuring of your employment, the what they call the org chart, the organizational chart. So their restructuring is a very wide word, but basically the aim is only one thing: how to actually keep enough cash flow for the company to sustain. So I think that is the my answer to this corporate restructuring. Of course, I mean, under the Companies Act, there are some legal terms about restructuring, but what I'm trying to say is it's a very wide word. You can do a lot of things for this restructuring, basically finding ways to survive.
All right, thank you. Mr. Arun?
Yes, Yvonne, thank you. Now, if you're talking about restructuring of workforce, that means if the business is slowed down to the extent you do not need that number of workforce which you previously had, then obviously there's a situation of redundancy, a surplus of labor. So you can reduce your workforce, provided that each category of workers, for example, if you have executive level, you need to have a selection criteria of who's going to be retrenched. Now, generally stated, the most fairest selection criteria is the last in first out. I mean, those who come last will be retrenched first. But is this a rule which has been codified as a law? Yes, but if you have some other criteria which are objective and fair, you can still apply those criteria. So, for example, you do not want to apply LIFO because you have other criteria. So long as those criteria are fair and objective, you can still do it. So basically, when you want to talk about retrenchment, it's a long process. Basically, you need to determine the selection criteria. There must be selection criteria of who you want to retrench, how many percent you want to retrench, how you go about doing it. So, of course, the most tried and tested method is the last in, first out, but sometimes it may not work for certain companies, right? It might not work for certain companies. For example, if in this situation, there are employees who have gone back to their states, and the company is in Selangor, and the workforce, they have generally about 8,000 workforce, but they now have 4,000 workforce. And they've decided that we only need 4,000. We're not going to ask the 4,000 to come back. Now, in this situation, can they say the 4,000 or other states, we don't want you to come back? Again, it all depends. If it is a fair policy, it can be done, because we say we don't want to take a risk of you all coming back here. So it all depends on how fairly and equitably you want to reduce your workforce.
All right.
Yeah.
Anyone that has any more to add?
Nope.
All right. Now, thank you for that. Now, in fact, I have one question. This is like from my point of view or my
Sure.
questions. That since we have been discussing about employment and the sustainability of the company, and that of course it is always a chicken and egg issue. Whether should I retrench my staff or whether should I maintain my company? But of course, I'm from employer's point of view, or especially like for those SME on commercial side. I don't even have enough of fund to sustain my own company or my business. So how can I afford to comply with the governments, even though, like we say, retrenchment is always the last resort? For example, at this moment, we see so many hotels, especially tourism industry, that they are shutting down. So whether should I obey the law or whether should I save my company first? So do you have any tips?
Well, ultimately, if you have no funds at all, and like for example, hotel industries, I mean, they are looking at a period of prolonged and even after MCO. Unlike other sectors where after MCO is over, they can kickstart. Tourism is probably going to take at least till the year end. What do you do with your workforce until then? So there
We have so many small hotels.
Yes, even small and big, their overhead is running, but there is no functions. There's no tourists coming in. There's no functions with the social distancing. No, no companies or the government will not want to organize any functions in hotels, and those are the main revenues for the hotel. So in those scenarios, if you have no choice, I think it would be much better to retrench, close down, and probably reopen again when the tourism sector starts kicking in. Because if not, the thing here is we are uncertain about when this whole thing will end. When will we go back to the normal we had? We are uncertain about that. So hotel owners can't be having an hotel, paying staff, and without any business. But for other sectors, like which can reasonably foreseeable that they'll kickstart operations. Now, for them to retrench, and then when the operations kickstart, you need more manpower, you need to hire people. That is going to be detrimental because if you've already trained workers with you, you have trained workers, you might as well keep them for a few months, get all the subsidy available, get the loans from the bank, get everything, sustain it, and when the production kicks back, when the operations kick back, your workers are already there. So it all depends on the operational sustainability of each and every SMEs themselves.
Okay.
Yeah.
So on the other hand, we can safely say that change of business model is also part of corporate restructuring, and in fact, it is safer to do.
Change of business model, that's for sure, because I think moving forward, digital is the way that all the companies have to do. So I've seen the session earlier. We discussed e-commerce. It is a very relevant area because digital is the one that bridge between you, your company, and also your customer during this MCO time. So we have seen a lot of people going online, from selling things on Lazada, for example, to selling seafood. I don't know whether you watch the seafood. There's one
Yeah,
from
yeah.
Singapore, 60 over 1,000 online live, so this various way of selling things online. So it's proven to be the quite successful. So I think yes, change of business model. We have to think from a legal point of legal industry. We have also start to think that how can we actually work more efficiently by using technology. And I think we have also discussed briefly before this. Even the virtual proceeding is broadcasted live for a court of appeal hearing. I think 2 weeks ago in Malaysia. So this is the way forward. So for those practitioners or the firms who are still quite traditional, refuse to move to email or online or do video conferencing, I think this will be a tough time. So I think change of model is very vital for this survival.
Okay, Arun, just now you talk about, for example, as Yvonne highlighted just now on the tourism industry, right, or hotel industry. So there are several of them are closing down. Is it, for example, if they said, okay, if I'm running out of cash now, and we need to wait for loans to come in, maybe it takes some time, or some financial assistance takes some time to come in, and therefore I want to close my entity for a while. Yeah, say I want to close for 3 months. Okay, but in these 3 months I can't pay my staff, but I will guarantee you that upon when I open up my business again 3 months later, you'll be hired back into my place again. Is this considered fair, or is it workable, this kind of method?
It is workable, especially for hotels. Normally, even before MCO, sometimes hotels go for large-scale renovations.
Right.
So during that period of time, they are rebranding themselves. They are doing a large-scale renovation. During that period of time, for 3 months or even sometimes longer than that, employees are not given work. But basically, what will happen is, if the hotels have got a union, they will have if the hotels have a union, the National Union of Hotel, Bars and Restaurants, and the hotel will probably have a collective agreement. They'll sit down with the union and they'll probably sign a supplemental agreement to say that your jobs will be preserved during this period of 3 months or 6 months. You will be entitled to your earlier rates, but during this period, you will be under unpaid leave. Now, if that is agreeable by both sides, then that agreement will stand in any court of law.
I see.
Because the agreement will be deposited in court and that agreement will stand in any court of law. Now, if there is no union, then you have to individually deal with all the employees.
Right.
And you get to get a consent from the employees to say that you agree to unpaid leave for X number of months, but your job will be assured once the hotel resumes operation.
Right.
So, and then you get it written and they got to get it signed from the employees themselves.
So that might be a better solution than just close down the whole business, right? Because you will never know when it will recover. But again, let's say if the union say, okay, we come up with a deal now and we have signed the deal, but if any of the employees they themselves doesn't want to follow, they have to choose to resign. Arun?
If the employees do not want to take, yes. Can you hear me, Dr. Brian?
Yes.
Now, normally in a collective agreement, it will specify that the union is the collective body for the employees. They are the
Right.
negotiating body for the employees. So the union's consent binds all the employees. But if for some reason some employees are feeling that they're not going to agree with this, then they probably have to resign and they probably will file a case for constructive dismissal.
Right.
But it will be difficult for them because union is the umbrella body representing all the employees.
Okay.
Because in terms of negotiations for better terms, it is the union which negotiates for the employees. So you can't have the cake and also eat it. You want
Right.
better terms, but when it comes to difficult situations, you do not want to agree with the union.
Okay. So
So you got to
what
Yeah.
about the other way around, right? If let's say they both agrees, the hotel owners and the employees agrees, and 3 months later, assuming that they actually resume the business, but these employees already got a job somewhere else. So will there still be a law issue, a legal issue in that case? Can the employer sue back the
Generally,
employee
if
in
the
that case?
employees have, it all depend on what was the agreement, what is the contents of the agreement.
Yep.
If the employee leaves, I mean, at most he will only be required to pay the notice period.
Right.
He's only liable to the notice period because you can't compel someone to work for an organization. Because that will amount to you. There's no specific performance or employment matters. You can't say you must work for me, right? Because that will amount to forcing someone to perform work for you. So ultimately, the choice of the employee. If he wants to leave, he leaves, depending on what is the clause in the agreement which states what he needs to pay. If there's a clause to such an effect, then he has to pay that amount. And if he doesn't pay, the company can file a case to recover it as a debt to the company.
Right. Okay, so there's a question by Shannon Boo here. When a company decides to retrench, would the retrenchment be based on KPI as a better solution than as using the LIFO method?
Based on what? KPI?
Yeah, based on KPI,
What is
correct.
it? It's
So just now we were
difficult
talking
to
about
do
if retrenchment, you use a LIFO method, right? But
Yeah.
those come in late, the newcomers, they might be someone who can perform better than some who have been in the company for a long time. So the question is, should they actually retrench those who are not performing instead of LIFO?
Right. The problem with this is it becomes very subjective when you say about performance,
Okay.
and it will be. You see, the LIFO is very easy application. It's across the board, so that means last in first out. So there's no dispute. When you talk about KPI, then if you retrench someone on a KPI, that person who gets retrenched will say that this is unfair, and the chances of it being challenged increases, as opposed to it being LIFO, because LIFO means tough luck. You came in last, you're out.
Yep.
So you can, provided, if say for example, an employee has been on medical leave for a year, and this employee is a senior employee, and there's another person employee who just came in. I mean, it doesn't make sense to say that the senior employee who has been on medical leave for such a long period of time needs to be retained at the expense of a junior employee. So each selection criteria has to be defended on a fair selection criteria. So LIFO is a general universal applicable principle. But if you want to depart from LIFO, your other principles have to be fair and have to be defendable.
Right. Okay. Another question.
So the answer to the question is you can go by way of KPI, but the KPI has to be objective. The company has to be very sure about the performance indicators of every employee and has to be prepared to be able to defend itself on its KPI. So the KPI has to be fair, fairly assessed, and it has to be objectively assessed.
Yeah.
I think for
Gets
this
more
issue,
complicated, right?
Yeah.
yeah, I think for this issue, I'll be getting quite a number of calls from my clients, especially during MCO, about this retrenchment. So
Yeah.
I look at it I always advise them look at it differently. Retrenchment is based on the assumption that everybody is equal, so that LIFO, the law says LIFO. But if the employee has got disciplinary issue, don't come in, don't give you the work that you ask them to work, and don't submit any assignments and all these things, those are disciplinary issue. You still can take action against them. And follow the due process, proper procedure. So it doesn't mean that during MCO or post MCO, you are not able to terminate someone and all this. So, for example, dishonesty or all this, whatever, you put it in the employment contract, those rights the employer still retain, you still retain. But when it comes to retrenchment, is everybody is equal, but how do I choose? So the law says LIFO, last in, first out, because logically, those who stay with you longer, they should be given the security of the job. So, but it doesn't mean that you cannot take action against those employees who are giving you issues and problem during this period of time.
Right.
Now, Dato Teh, we
Yeah.
have a questions here. Like
Yeah.
it's literally based on online shopping. Does
Yeah.
Malaysia have the law to protect consumer and also the seller? Do they have any law to support them?
Yes, I think you see, shopping, whether online or offline, is a contractual thing. It's law or contract. So it's the same thing whether it's online or offline. So in Malaysia, we actually have the e-commerce act. I think there are a few acts at the last session. I think there's the lawyer, Mr. Chan, has actually discussed about this. What I'm trying to say is the basic of the law is the same. Law of contract, offer acceptance with supported by consideration. So everything else, the basic principle are the same. So again, you go to the online. So what are the laws to protect specifically online? It's the same thing, buyer beware as well. You go there, you look at the seller. If you is from Lazada, usually you scroll whether what are their comments, are they a very good seller, very good comments. But if you are just looking at a very this ad, advertisement on online platform, some weird names, no company details, and yet you go and buy, then yes, then you are trapped. Then we have heard about a lot of people got cheated during this MCO, even buying masks and a lot of
Yeah.
other things online. So I think the basic principle, the law does not grant additional thing when you're buying online. Online is just another way of channel of distribution, but the basic principle is same. It's the same. You have to check the seller's background because you do not see the goods on in a physical form, so it'll be delivered to you. So I will advise people to actually go for the reputable platform, because the money is paid directly to platform. Then platform will actually release the money to the seller later when things are okay. And likewise, people can do a peer comment on that. Other than that, the law is a law to protect the seller and the purchaser point of view. It's the same protection. It's the same protection. It is only that the cases of fraud when you are transacting online, perhaps it's a bit higher because you don't see each other. So be a bit more vigilant when you do online shopping, although this is a way. But if you're doing online shopping from the reputable platforms or from a reputable company directly to their website, I don't see much of a problem on that.
I see. And as what the session we had last Thursday was on cyber law, right? So they are
Yes.
specific cyber laws in Malaysia enacted
Yes.
to protect both seller and the buyer, right?
Yes, basically, is the cyber law gives the recognition for the transaction to be done online. But the basic
Right.
principle is still the law of contract, where buyer sells and you buy and you pay the consideration and deliver goods to you. So I think the basic
Right.
principle is still the same. So although the law is there, for example, online e-commerce, the cyber law is there, but it does not guarantee you that you will not get cheated. If you
Right.
go in with closing your eyes, you're still able to get cheated in this circumstance. So yes, I see another
Right.
question from the beginning. What's the name of force majeure? I think then
Yeah.
someone
Yeah.
FORCEMAJURE. Yeah,
Yeah.
I think it's a French word. It's a legal principle to actually relieve or to freeze the parties' contractual obligation during this movement control, or we sometimes people call it the lockdown in certain countries. So you're not able to perform, so therefore you are not liable to the delay or the damages during this period. But those who want to watch this, you can actually go to my Facebook. I've done in the video and also some short videos to do a basic explanation of this force majeure.
Okay, so for Jacqueline, your question on the online shopping, the cyber law, for example, yeah, there are in the previous session, you can actually watch the video, which is uploaded on UOW KDU YouTube channel now. You can look at some of the specific laws being suggested by the panelists at the time, yeah. So you can have a look at that. Just my interest now when Dato, when you talk about online businesses, even though there's a cyber law, I also understand that certain products, when you need to promote, for example, advertise, for example, you also is also abiding to different other laws as well. For example, we talk about healthcare products, right? You also need to get approval from KKM before you can actually
Yes.
advertise that particular product, right? So what happens if nowadays people do a lot of live commerce now? Yeah, we talked about live commerce also in the earlier session. Someone just put live into YouTube, YouTube or Facebook or Instagram, try to sell some vitamins, for example. Yeah, just talk about simple vitamins. Is that allowed without the approval of KKM?
Strictly speaking, you still have to comply with the law. Before this, where people put out advertisement in a written, in a design, the e-poster, it's easier to catch. When it's live, then when I'm just selling you, hey, this product, for example, this thing and how much. The problem is with tracing by the authority. Are they going to watch hundreds of hours of live videos to go and catch? But if they want to do it, yes, they can, because advertising a medical products, you have to get the approval from the KAM in order to sell it. So the obligation to comply with the law, whether it's offline or online, is the same. The basic principle is the same.
Right, because I also sometimes see some of the brands, they use some influencers, social media influencers or some artists to highlight certain products for them. I think it's a good advice for the public or whoever who are interested to promote the products online or live commerce itself. Just make sure that there are different sets of law and regulation for you to address. Yeah, not just to concern. Not just the cyber law alone itself. Yeah, just to let you know first. Okay.
Yes.
Yes.
Dr. Brian, I
Yes.
see someone asking about what is LIFO.
Yeah.
Shannon, now LIFO is last in, first out. Basically, employees who come in last, junior employees would be retrenched first. Now, bear in mind, of course, it is a standard application. But for example, if you have, it has to go on the category of employees. So it is not just on your service. That means, for example, if you've been a clerk in a bank for 20 years, and then you were promoted to become an officer, and you're an officer of 5 years. Now, it's not 25 years. It is 5 years. If you are going to be retrenched as an officer, it is just 5 years. It cannot be the entire period of your service in the bank. Service in that particular category. So if it's your service there is 5 years, and there's another officer who's been there for 10 years, obviously you'll be retrenched. Even though you will say that I'm in the bank for total cumulatively 25 years. So last in, first out doesn't mean just service alone, blanket application of just your service in the company. Service in the position or in that category.
Right.
Right. So if you have been a clerk for 20 years, promoted as an officer of 5 years, and there is another officer who's been there for 10 years, you will be the last to go, even though in the bank totally you have been 25 years. So a lot of people get misconception. There's a misconception saying that it is the entire tenure of service. It is actually the tenure of service in your category of employment, in your position of employment.
Right.
So which means which means if let's say any, like just now we did mention, like Mr. Arun did mention, you can also look into another alternative, like removing your problematic staff. If let's say your staff it's really causing disciplinary issue, so would that staff be able to sue the company?
I think if you want to remove someone as a problematic, you follow the due process for disciplinary issues, not go under retrenchment. That means you serve them with the requisite show cause, ask them to explain, and then move towards dismissing them for disciplinary issues. I think if you lump it up together with retrenchment, it becomes an issue.
What if there is no disciplinary action, nothing, but you just couldn't afford to hire a senior staff because it's too expensive. So you literally make that staff a scapegoat. So like you're forcing that person to leave. So can that person actually take actions?
Well, obviously, if there's no grounds, I mean, and if the retrenchment itself has got no fair basis, obviously, if it's a senior person and a junior person, just purely on issue of cost, then obviously there's going to be a challenge. Obviously, it's going to be disgruntled. Obviously, the senior employee will say that I've served you that long, and there is some sense of at least a duty of loyalty to the company, and yet I'm not rewarded with anything. So that's why in most cases, if there's a senior employee and you want him to leave, it would be rather better if you go for a mutual separation scheme. Negotiate a scheme where he is happy, give him payout more than the minimum given under the Employment Act, and then sign the mutual separation scheme, and then therefore the chances of him taking the employer to court becomes very less. And even if he takes them to court, he basically has got very little grounds to succeed.
And then, of course, on top of that, there is the questions like where and how could employees start to take actions against the company?
Correct. So where? Sorry.
Where and how could the employees start to take actions?
Well, if they are not happy with being dismissed, either because of retrenchment or dismissal, of course they can go to the industrial relations department within 60 days of their termination, and then the matter would be referred by the minister to the industrial court for adjudication. And during industrial court will decide whether the termination is fair. But in this current climate, where unprecedented situation, where employers are having cash flow situation, which is undeniable, retrenchments will be hard for employees to justify unless it's clear-cut done in bad faith. If not, generally speaking, I doubt the courts will want to interfere with the management decision of retrenchment if the management themselves are bleeding.
So which means at the end of the day, like for businesses, any type of businesses, as long as they followed the proper way of not to say removing, but ending the relationship with the employee, so everything will be good.
Yeah, ultimately the word is applying common sense. If you act sensibly, I mean, if you tell the employees, look, we are in this situation, if you discuss the employees and then give them a proper notice to look for another job, you comply with the notice requirements, and you have a objective criteria based on your organizational needs, it will be quite difficult for any employees to actually challenge that. So as long as you are fair and transparent and you apply common sense in the way you do about it, so I mean, I think it will be difficult generally for the employees.
Okay,
Right.
okay.
I have a last question. You may have to take the last question here because it's already 3:55 now. Yeah. There's a last question here that I received separately as a message here. Just now when Dato was talking about the attendance or the condition where during MCO you actually can fire people, right? If there is a good ground on that. For example, at work, in the physical work, there is a clock in, clock out, yeah, to know whether the staff actually goes to work or not, yeah. But during MCO period, when they work from home, this employer try to call or get in touch with the employee and just couldn't get the person, yeah. Will this be a ground of disciplinary action for that? Can they do that without any evidence or something? What kind of evidence they have to show in that case?
The evidence is to give a proper mechanism to say that you have to, clocked in, or there must be a mechanism saying that let's start working at 9 o'clock. If you refer to the Ministry of Human Resource, their FAQ also got as a one word, can employers ask employees to work from home? The answer is yes, because during MCO, it doesn't mean that you get gaji buta and sitting at
Yeah.
home. You are supposed to
Yeah.
work from home. Working from home also means that there's a mechanism to say clocked in. But if they say everybody please, for example, checked in through your WhatsApp group, for example, and you consistently fail to do so, then you have to go through the due process, like show cause letter and all this process.
Okay.
Then you can take the disciplinary action against the particular employee for failing to do certain things. So the
Right.
right is still the same. Mm.
But if the employer doesn't indicate this kind of process in between, then is it an argument
And
then?
yes, then you can't say that, because you didn't tell me that I have to check in every day 9 a.m. by certain mechanism. So
No, for
suddenly you say
example,
I'm not responding. Mm.
yeah,
Mm.
say that before the MCO started, they have sent out an email to everyone, right? That your working hours is from here to here, this time to this time, but you work from home.
Mm.
Yeah, but
Mm.
I do not require you to have a clock in WhatsApp or your system,
Mm.
whatever not. It doesn't require us, but as long as when we need to look for you, you are available during these hours to these hours, for example. So
Mm.
is that good enough?
I think during the MCO, employers
Yeah.
difficult to just adhere to a 9 to 5 for the employees to work for home, because you got to bear in mind some of the women, the mothers have children at home, because even schools are closed. So during that period, they probably have to cook for their children.
Yep.
So if you say 9 to 5, it generally is difficult to work as long as work is done, regardless of the day. It's up to 12 o'clock in the night. You have the facilities to do the work. It is done. It should be fine. So if the employer tries to call the employee and the employee does not answer the call or does not respond to the email, and I mean the best prudent thing will be to email him and ask him why. Get his explanation first, because in this
Right.
period, we are all struggling with this new, and then we don't know whether the technological failure.
Right.
Luckily, this 1 hour we could hear each other over here, but sometimes we don't know the problems we are facing. So
Yes.
the prudent thing is to err on the side of caution. Ask the employee what happened. Why didn't you pick up our calls or respond to our emails, and get him to see what he says.
Okay. Okay.
He might have a child who's sick and he had to rush the child to the clinic. We
Mm.
never know.
Yeah.
So it's not really
It's the
all
same
about
thing.
So it's not really
It's
all
the
about the legal matters only, but also the humanity concern as well, right?
That exactly. I mean, it's the
Yeah.
same thing if you're in office. Let's say the employee is consistently late. They also have to issue a show cause letter asking for explanation. And during
Okay.
MCO, I had to agree with Arun as well. Sending a message, the employee fails to reply within 15 minutes, that does not amount to they are not doing the job. So,
Right.
I think replying after a few hours within a working day, I think that's fine. But, if you have a situation that you send out the instruction, and they have not responded to you and they totally locked off in the past 3 days or 5 days, then
Yeah.
that you have to email to them, ask for explanation and things like that. I think a little bit of human sense as well during
Yeah.
this tough time. Yeah.
So
He
those
is to
are
be
the people where they
reasonable
go
in
offline, right?
circumstances. Yeah.
Yeah. But so what Dato is talking about is those people who go offline for a while, which you can't get them at all, right?
Offline for the company's chat group, but they are very active on Facebook. So that
That is
is
very
also
true.
another.
Yeah.
So you have to take all the facts into consideration, right?
Right. Understand.
Yeah.
Okay, great. Thank you very much, Dato, Teh, and Arun as well for your great thoughts and insights here. A last piece of advice from you guys to the audiences, please. Dato, yourself first.
I think during this is unprecedented. So I think the way how to move forward is we have to think different ways. But I personally think that in terms of businesses, do not actually jump into litigation right away after this, because I think we have to keep the resources both from the company point of view and also the employee and the suppliers and the customers. I think don't just jump into this litigation right after this. In fact, Malaysia, we are drafting our COVID-19 law, and hopefully it will be tabled in the July session. I think May session, the minister is already said that they won't table it. I'm looking forward to the July session so that to
see.
make the situation better. So I think apply humanity in terms of these entire processes in the next 6 months or 12 months. Be it you are an employer employee. I think
Right.
this is unprecedented. So don't jump in. Don't spend your resources in doing litigation, but see how you can negotiate or find a ways a solution. But when you find the solution, make sure that you get a good lawyer like Mr. Arun. If you
Yep.
get the employment contracts, for example, review it. If you say that, oh, there's an agreement to pay cut, for example, or I agree on this, I agree on this mutual separation scheme, things like that. Don't do DIY just to save up a few thousand ringgit. Get a lawyer to do it, and that will save a lot of other trouble. Similarly for law or contracts, your contract, you negotiate, then put it in writing, and do it
Right.
properly. Yeah.
Okay, great. So when the COVID-19 law is approved, then maybe we'll call you guys up again, yeah, for another session.
Sure. I'd be happy to do that.
Well, thank you. Now, Mr. Arun, we have one last questions for you. And then maybe after these questions, we want you to give us, of course, a piece of advice as well. Now, this questions comes from our participants by asking, if the personal problems affect work from home, the boss doesn't understand humanity. So the boss takes actions as disciplinary. Are you allowed to sue the company? But the work is done.
Again, it all depends, you see, on, I mean, if what is the personal problem during this MCO. And if ultimately the employees, my advice is during this period of time, SMEs have to be, employers have to understand this is a difficult situation for both. So a little bit give and take has to be there, right? And and probably not even a show cause, just an email to ask, are you all right? How's things? And then what's the situation? That would be the start first. And then get the feedback from the employee. But if the employee is persistently ignoring, then probably the employer has got no other choice but to move on to the next process to issue a show cause letter. Now, if the employee is not happy with the disciplinary action, if he is dismissed, he has got his rights under the law. So he can file for unfair dismissal under Section 20 of the Industrial Relations Act, and he's got rights under the law. Ultimately, the court will decide based on the facts, based on the reasonableness of circumstance, reasonableness of the situation, whether the employer acted in accordance with the law. Now, I think that will be my answer to that particular question.
And your piece of advice, maybe a
Yes.
little bit about what you do in the Legal Aid Center as well as the panel of the employment division.
Sure. Now, in the Legal Aid Center, we advise on walk-in clients, for employees who have employment-related matters, ranging from dismissal issues to issues of unpaid salary, to also issues where employees are injured during workplace. So now, if you are probably injured or if you suffer from COVID-19, that's also an occupational disease under SOCSO, which you are entitled to claim.
Oh, okay.
So if you contract COVID, it also becomes an occupational disease. That is for those who are frontline workers. But if you are infected, you are also entitled to medical leave protection under the SOCSO. So over and above that, there's protection under the SOCSO for those who, because of this pandemic, those who are infected from COVID, we get those benefit from SOCSO. So we advise on all kind of issues, ranging from employment-related issues to SOCSO and so on. And my last piece of advice would be is that we are in this together, both employees and employer. We are in this to sustain ourselves. Both employees need work to sustain their livelihood. SMEs need business to go on, to sustain their family, and to keep the community going. So we need to work together. We need to ensure we get through this together.
All right. Thank you.
Thank you.
Okay, thank you very much. Yeah, for both Dato Teh as well as Arun Kumar here. Just to give some credits to the sources used in this session here today, just to share. And if any one of you have any questions, you can always contact us via the email or the WhatsApp number, as you can see there. And also do follow us on our Facebook, Instagram, and YouTube as well, our channels, UOW KDU. Yeah. If you have missed out the earlier sessions, you also can watch all the videos uploaded on our YouTube channel as well. Okay, so with that, thank you very much everyone to attend this evening session, and appreciate really a lot to our two panelists, Dato Teh as well as Arun Kumar. Thank you so much everyone,
Thank
and have a
you.
good and safe
Thank you very
evening.
much. Thank you.
Bye-bye.
Thank you. Bye-bye.
Thanks, Yvonne.
Thanks, Brian.